Today we are focused on the Karen Read wrongful death case. We're going to go to the triplet of filings with the Karen Read emergency motion for reconsideration regarding all the Proctor stuff, and then Proctor's opposition, and then the reply, and then the court order. We're going to go to that first. Emergency motion for reconsideration of order delaying deposition of Michael Proctor. I mean, it seemed to stay all discovery. Defendant Karen Read respectfully requests that the court reconsider its June 29th order staying further discovery of Michael Proctor. They say the court stated on the record that it stayed the second day of Proctor's deposition because an attorney with an appearance in this case had, quote, violated either the letter or the spirit of the rule. They go on to say the statement is incorrect. Y'all, they're just going to keep locking horns with this judge. I don't think they care. But we already know that this is going to make the judge prickly. First, they say the ex post that the court cited as the only evidence that its impoundment order had been violated was actually posted before, underline bold, Proctor's relevant June 8th, 2026 filing. Second, the information that the court claimed had been discovered by an attorney, I'm not going to yell this all in my bold voice, underline bold, was already public as of June 6, 2026 at the latest, more than 2 days before the filing or impoundment order at issue. Footnote 1. Read's counsel was prepared to present the evidence presented here at the July 1st in-person hearing. However, after delivering its prepared remarks, the court left the bench and refused to allow any party to be heard. It goes on to say, thus, the foundation upon which the court relied to suspend Proctor's deposition was mistaken, and the court should vacate its order to avoid unnecessary delay in discovery, particularly where the second day of Proctor's deposition is already scheduled for July 14th. Oh shit, that was yesterday. The thing is that the lawyer's argumentation isn't wrong. The problem is that the court said that they do not know which lawyers leaked anything, but the court believed, based on the limited things that it apparently had seen, that this information must have come from one of the attorneys. And so the remedy for the court was to pull everybody into court and admonish all of the lawyers and yell at them, and then tell them to all have a good 4th of July. But when the court stayed the discovery for Proctor, the only party that really hampers is Karen Read. I am open to discussion about whether the Read party is not the most impacted party by delaying Proctor's deposition, but I do think that the Read party is probably the party in the wrongful death lawsuit that is the most impacted by not being able to continue with Proctor's deposition. I don't think the bars care. I don't think CF McCarthy's in the waterfall is like, okay, whatever. And I don't know if the O'Keefe parties are all that pressed about it either. Because the O'Keefe party's side of this is we're suing Karen Read for wrongful death. The investigation was fine. But Karen Read's team is not going to back down on this point because they are the party being impacted, and I don't fault them for that. The sassy footnotes are not going to help, but also I don't think there's any way to bring the temperature down on this at the moment anyway. So they've done what I'm not surprised that they did, which is they tried to bring out the same information in a different way because the judge said, this is not what a motion to clarify is for. Fine. Here's a motion to reconsider. Let's do it that way. Read brings this motion on emergency basis because the second day of Proctor's deposition is already scheduled for July 14th, and all counsel and parties have already planned for that date. It is particularly important to protect this scheduled date because Proctor previously asserted that he had limited availability. It would be unduly and unnecessarily costly and burdensome to force Read to miss a previously scheduled deposition day because of the order. I disagree with the languaging. I don't disagree with the sentiment. The vibes are accurate. Were Read to serve this motion via Rule 9A, the opposition would not be due until after the currently scheduled date. Read's counsel confer with Proctor's counsel concerning the motion prior to filing. So Read's counsel is saying we told Proctor's lawyers we were filing this because now they have to let Proctor's lawyers. I think in this context, that's correct. But remember, the court clapped back at Read's lawyers and we're like, did former trooper Michael Proctor's lawyers know that you were suing MSP the day before his deposition? And they're like, huh? What? Why? Why would we do that? We're not suing him. He's already been sued. So they reminded the court, yes, we've already told him we're trying to speed this up. They go on to say the court's remedy for what it incorrectly determined was a violation of its impoundment order has primarily impacted Reed. I'll keep reading, Emily. I mean, again, this is obvious, right? They are the party who subpoenaed Proctor, began taking his deposition, scheduled a second day of testimony, and spent significant resources compelling and taking his testimony. Additionally, despite the fact that there is no evidence of any violation of the court's impoundment order, Reed has, as the court instructed, made a proposal to all parties concerning an order she would agree to propose to the court concerning deponent's medical information. Oh, interesting. And I don't think Karen Reed's attorneys or any of these attorneys are trying to put Proctor's personal medical information out there. However, his attorneys were pretty forthcoming in the hearing that was public that it was medical information that they were submitting. Reed has proposed an order to all parties. No other party has responded to Reed's proposal. Shocking. They're all not talking to each other. They go on to say that this comes on the heels of Reed earlier proposing to all counsel that witness testimony in transcript, audio, or video form only be used for the ongoing litigation and not otherwise disseminated. So they asked the court to reconsider and vacate the order and allow Reed to proceed with Proctor's deposition July 14th. We need to take a look next at Proctor's opposition. Non-party Michael Proctor's opposition to Karen Reed's emergency motion for reconsideration of order delaying deposition of Michael Proctor. As an initial matter, Ms. Reed's motion should be denied because it fails to even address the fact that the information regarding Mr. Proctor's _medical condition and his deposition was disseminated by Aidan Kearney, aka Turtle Boy, within 30 minutes of the conclusion of Mr. Proctor's June 25th, 2026 deposition. Didn't the court issue the order regarding a tweet from before the deposition? Why are we moving the goalpost? Specifically on June 25th, 2026 at 5:30 p.m., Mr. Kearney posted on his X account, and then they put the handle in at Dr. Turtleboy as follows. Quote, breaking news. Michael Proctor claimed, in bold, to have a panic attack today and left his deposition, emphasis added. Wait, did the lawyers add the emphasis? Why add emphasis? I have personally verified that, and they say spelling and original, that was seen outside. I don't know if that said Proctor or something else, that it was seen outside being consoled by his lawyers who were asking him if he could continue. No word yet if he did. With everything going on, eyes are on these parties. I have the sense that those in the greater Boston area don't have a lot of love for Proctor, or at least the ones that don't have a lot of love for Proctor aren't going to hesitate to DM Turtle Boy and be like, yo, guess what I saw? That shocks me not. They go on to say, this is Proctor's attorneys, that the information was accessed by a user with an X account, footnote 1. A screenshot of the X post follows. So they have a screenshot of the tweet from 5:30 p.m. June 25th, 2026. Well, then why did you quote it above? In point of fact, Mr. Proctor did continue his deposition, and the deposition was suspended shortly after 5 p.m., assuming arguendo that the X account did not default to 1:30 p.m. Eastern Standard Time, and they put default in quotations. And given that this X post was accessed by a user with an X account, Mr. Kearney posted on X within 30 minutes of the conclusion of Mr. Proctor's deposition that Mr. Proctor, quote, claimed to have a panic attack and left his deposition. Accordingly, the fact that Turtleboy posted that, quote, Mr. Proctor left the deposition, end quote, but had, quote, no word that he did, end quote, continue the deposition, strongly implies that Turtleboy had this information while the deposition was ongoing. Maybe from somebody that saw him outside? They are making the conclusion that Turtleboy had information while the deposition was ongoing. They say, more importantly, the fact that Turtleboy posted that Mr. Proctor, quote, claimed to have a panic attack today and left his deposition implies that Turtleboy was aware of what was said during the confines of the deposition, footnote 2. So it's true then, footnote 2. As noted above, in response to another ex-user's request that Mr. Kearney, quote, post the pic, Mr. Kearney responded, can't, unfortunately. Why is that a footnote to that sentence? They go on to say, to be clear, at no point has Mr. Proctor, quote, pointed the finger or otherwise accused any counsel or party of disseminating impounded information. Huh? They've started their conversation in the middle and haven't clued the rest of us in on their conversation. They go on to say, given, however, the existence of the court's orders of impoundment and the sensitive nature of the impounded information, Mr. Proctor felt it appropriate to bring to the court's attention information which created a reasonable inference of a violation of the court's orders. Those are the exact words the court used too. As the court noted during the July 1st, 2026 hearing, all parties and counsel certified to their lack of knowledge as to any facts regarding the potential dissemination of the impounded information. Right. Mr. Proctor's June 25th, 2026 deposition went forward for approximately 4 hours and 30 minutes with several agreed upon breaks. Mr. Proctor is a fact witness in this litigation and not a party. Despite having the opportunity to depose Mr. Proctor for hours, at no point did Ms. Reed's attorney ask a single question regarding Mr. Proctor's investigation into John O'Keefe's death. Really? Wouldn't they just start with that? They go on to say, nor a single question about Mr. Proctor's investigation into Ms. Reed's involvement in that death. It seems to me that counsel's trying to imply that the time is not being used well in the deposition and the court should not allow the deposition to continue because they didn't use their time wisely. It seems that that's the direction that they're going in. Instead, Ms. Reed's counsel spent much of the deposition questioning Mr. Proctor about various text messages that Reed's attorneys published in a recent lawsuit currently pending against the Canton Police Department and MSP. That is not going to make the court happy at all, because I don't think the text messages are the most relevant part to the wrongful death lawsuit. They go on to say that none of these questions were relevant nor material to Mr. Proctor's investigation. I think they're relevant to the investigation. I think starting with the investigation would have made more sense, but again, it's not my strategy. And this is Proctor's attorneys playing to the court, because the court has been very sensitive whenever the word strategy is used, even though being a lawyer is in fact strategic. Every time the word strategic is used, the court gets ruffled. Nor were they relevant to the subject matter of the wrongful death action. However, part of the wrongful death action is Karen Reed speaking about this investigation. Those text messages, I think, can go at times to the investigation. Starting there is not helpful. Such questioning can only be viewed as harassing in nature. They say, accordingly, should the court allow Proctor's deposition to continue, Proctor requests that the court limit it to 3.5 hours of deposition testimony. Interesting. Finally, Mr. Proctor points out that on June 18th, 2026, counsel for Mr. Proctor requested from Ms. Reed's counsel, quote, assurances that neither you nor anyone on Reed's team will disseminate to any outside source, including but not limited to media and or social media platforms, any portion of the deposition, whether in video, audio, or transcript form. Despite being the party that subpoenaed Mr. Proctor and the only party that questioned him on June 25th, interesting, Ms. Reed's counsel has continued to state that they will not provide such assurances. They go on to say, regardless of whether the court allows Mr. Proctor's deposition to continue, Mr. Proctor respectfully requests that the court issue an order to Ms. Reed's counsel prohibiting them or anyone else on Reed's team from disseminating to any outside source, including but not limited to media or social media platforms, any portions of Mr. Proctor's deposition, whether video, audio, or transcript form. Outside source, including media or social media platforms, is fine. It's the but not limited to language that's a problem, because if you're putting yourself in the position of Reed's attorneys, you could see that if they gave an expert this information, that you could see Proctor's attorneys coming back and saying, but that's included. So I can see where all of the attorneys don't trust the intent of what is said and are worried that they're going to end up fighting in the weeds, because that keeps happening. And Proctor's attorneys in this opposition said, oh, we're not talking about June 8th. We're talking about June 25th. Silly. When the court was the one that started talking about June 8th. So let's see what Reed's attorneys have to say when they respond. This is Karen Reed's reply in support of emergency motion for reconsideration of order delaying deposition of Michael Proctor. As the court and Michael Proctor's counsel are aware, Reed has already specifically addressed the different ex post included in Proctor's opposition. Really? Oh my God. It really is like kids fighting at this point. So there are other filings where this was addressed. Reed did so in Reed's letter to the court in response to Proctor first raising this issue in a letter on June 26th. So this is new information. Reed addressed the Turtle Boy tweet from June 25th in a response to the court because Proctor's attorneys went to the court and raised the issue on June 26th. Those are not on the docket. As Reed explained in that letter, the post Proctor cites from Turtle Boy itself states, quote, Proctor was seen outside being consoled by his lawyers who were asking if he could continue. No word yet if he did. They left some of that information out, though. Proctor's side has the whole quote. Breaking news, Michael Proctor claimed to have a panic attack today and left his deposition. I have personally verified that he was seen outside. Reed's team left out the claimed to have a panic attack today and left his deposition. That was the part that it seemed the lawyers were the most fluffed about because, of course, they're fussed. That information seems to come from inside the building, not outside the building. And Reed's team just kind of sidestepped it and put in half a quote of Proctor was seen outside being consoled by his lawyers. They go on to say someone outside of the deposition saw him and Mr. Carney was unable to report whether or not the deposition concluded. They're not addressing the issue, though. They go on to say this does not suggest in any way that someone in the deposition shared any information with anyone. In fact, it suggests the opposite. You skipped half of it, though, counsel. Proctor spent multiple hours outside the office where the deposition took place and presumably sometime outside the office building. Carney's post explains that the information he shared made its way to him because Proctor and his counsel were observed in public. Other social media activity provides even more detail on how this information became public. And then there are screenshots. I mean, at least they're using dark mode. There are screenshots of other tweets. One that's a reply to a post that we don't have, but there's a reply that says he showed up and had a panic attack in the hall outside. And that's from 11:29 a.m., June 25th. But I don't know what that's replying to because we don't have that. Somebody asked prediction or fact. And then the user says, I saw it with my own eyes on a security camera, but cannot share it. I imagine building security is going to be interviewing everyone. They go on to argue all of the available evidence suggests that the information in question came from someone unrelated to the case. The remainder of Proctor's opposition is essentially a motion for protective order, which Proctor has not filed and Reed has not had the opportunity to oppose. If Proctor serves or files such a motion, Reed will oppose it. The opposition will point out that 1, Proctor's description of Reed's counsel's questioning is inaccurate, and 2, Reed's counsel extended Proctor the courtesy of delaying the start of the deposition for 2.5 hours to accommodate Proctor's stated needs and should not now be punished for that as Proctor requests. Finally, Proctor's statement that Reed's counsel, quote, has continued to state that they will not provide assurances regarding the use of deposition transcripts and recordings is false. Reed's counsel has repeatedly and consistently, including in a 9C conversation yesterday with Proctor's counsel, stated that Reed will agree to the restrictions Proctor's counsel requested if all parties to the case agree to them. That's not unreasonable to me. Emails evidencing Reed's attempts to obtain all parties' agreement have been previously filed with the court. Plaintiffs have refused to respond to Reed's proposal, which mirrors Proctor's. Really? The O'Keefe parties are like, no. Or is it just now that lead counsel for plaintiffs just doesn't want to respond to Reed's emails? They have gotten themselves into an untenable working situation here, where it's beginning to feel like if Reed's attorneys are like, hey, ABC, the other lawyers are like, no. And then if some other lawyer was like, hey, ABC, the parties would be like, yeah, okay. Reed respectfully requests that the court reconsider its order. These motions are getting us nowhere because everything is just a little bit spun. July 10th, 2026. This is the court's endorsement order. I have been presented with a motion for reconsideration of my order precluding further attempts to take discovery from a non-party pending further orders of the court. Ms. Reed's attorneys are reminded, the court says, of the provisions of Superior Court Rule 9A-A3 that a reply memorandum is to be limited to matters raised in the opposition, which were not and could not have been anticipated and addressed in the moving party's initial memorandum. Your Honor, that's bullshit. Can we just call this what it is? How could they have anticipated that the argument would be relating to June 25th when the court's order was clearly relating to June 8th? Let's logic this through real quick. Reed's party asked the court to reconsider the order made to stay Proctor's discovery. The court said that that was being stayed because of the June 8th tweet that the court said came out 30 minutes after Proctor's attorneys sent impounded material to court and counsel via email. If they had brought up June 25th in their motion, the court would say that it's not related. The motion misstates what I said. What I said was, I'm reading this directly. What I said was, orders of the court have been violated either directly or at the very least in spirit. I did not say what is stated in the motion, quote, that an attorney with an appearance in the case, quote, had violated the letter or the spirit of the rule. I do think that the court connected that to an attorney with an appearance on the case. But I do think that the court's direct statement was regarding the court order, not the rule. I also did not state on the record that, quote, I had stayed the second day of Proctor's deposition, but rather stated that, quote, because the disclosure of sensitive private information, I temporarily stayed further discovery of a non-party. I agree that that's what the court said, but the impact of what the court said, the practical effect of what the court said, was to stay the second day of the deposition. I don't think they quoted that the court said, I'm staying the deposition. I think they stated that that was the impact of it. Was it in quotes? Now I need to know. The court stated on the record that it stayed the second day of Proctor's deposition because an attorney with an appearance in the case had, quote, violated either the letter or the spirit of the rule. That's why the court's taking issue with it, because that's not what the court said on the record. That is the impact of the court's ruling. The court says that the court said, quote, because of the disclosure of sensitive private information, I temporarily stayed further discovery of the non-party. Now, the court is putting that in direct quotes, and that's not the direct quote either, because I think the direct quote was, I am temporarily staying further discovery of the non-party until further order of this court. So I don't think the court quoted the court correctly. Oh my God, you guys. I acknowledge the information in the motion as to the time of a June 8th, 2026 post on X. Is that the court acknowledging that they're wrong then? Because it seems like the court is acknowledging that the timing of those Twitter posts were incorrect. It's a terrible sentence, but it seems that both the court and Proctor's attorney are having a really hard time with the simple sentence of the timing on that tweet is wrong. It happened before the information. It raises concerns as to how people know this information. The court says, however, such information does not allay the concerns that gave rise to the order, especially given the content of a June 25th, 2026 post on X. The motion for reconsideration is denied. The court moved the goalposts. Oh my God. That's so annoying. So where are we at now? Well, the court moved the goalposts. We get to the end of the court's snarky endorsement order, and the court says in a incredibly poorly worded sentence that is unclear, like, keep it simple, y'all, keep it simple with the clear. But the court acknowledges the timing of the June 8th tweets, but then goes on to say that it doesn't matter. However, the court is still concerned because of a June 25th, 2026 post on X from Turtle Boy. And because of that, the court denies the emergency motion. What does that mean, Emily? Well, it means that discovery as to former trooper Michael Proctor is still stayed because of things that Turtle Boy said on Twitter that Karen Reed's attorneys have come into court and said, but this doesn't relate to us. And the court's like, I don't care. I have concerns. Denied, counsel. So did Proctor's deposition go forward? I would suspect not based on all of this, because the court's stay is still in place and the court denied the motion. So Karen Reed's attorneys came in and said, Your Honor, look, you had concerns that sensitive information was disseminated. The tweet came before the information was sent to the court or counsel. So can we please lift that stay? And the court said, yes. I see that. But it does not allay my concerns, because now there's this additional June 25th post regarding Proctor's deposition. And Reed's attorneys came in their reply and said, yes, but this is the information that was on social media. And the court said, denied. What can the attorneys do about that? Not a lot. Order relative to docketing. The quote, notice pleading e-filed on July 9th, 2026 at 3:46 p.m. by Miss Reed's attorneys shall not be docketed. The parties should refrain from filing such, quote, notice-type pleadings unless they are required under applicable rules or are requested by me. On July 1st, I did encourage the attorneys to confer and to seek to reach an agreement, and I further stated that in the absence of an agreement, I will consider whether to enter an order based on my plenary authority to control, manage, and oversee the conduct of discovery. In my July 6, 2026 order, paper number 152, I stated that if no such agreement was filed before 4:30 p.m. on July 9th, I would issue further orders I deemed appropriate. I did not request to be notified as to the progress of discussions between counsel. I also questioned seeking to put the emails relative to communications from various counsel on such issue on the docket. I see. The court does not want the docket used as a way for the attorneys to slap at one another. Too late. And believes that including all of the emails back and forth from counsel would serve no other purpose than for the attorneys to say, well, they won't respond. We're trying to come to an agreement and they won't respond, which I'm speculating about based on what Reed's attorneys said in the other motion. So basically, Emily, what is the court saying? The court is saying that Reed's team filed a notice pleading, which was just giving the court a heads up on conversations that the attorneys were having. He didn't ask for that. Reach an agreement and file it, or don't. But do not put all of this information on the public docket that I didn't ask for. The public docket is not to be used as a way to, and I'm quoting a little bit of the federal rule on this, but that the docket is not to be used to generate headlines, information. It's not to be used to just air grievances. However, I do not find this consistent for this judge with every hearing. Well, where are we at with this? And where are we at with that? And where are we at with this? So you file this on a Monday and he might be like, oh, okay, you tried to reach an agreement and you didn't. You file it on a Wednesday and he's like, why the fuck are you giving this to me? It's frustrating. July 10th, proposed discovery order. On July 1st, I invited counsel to come to an agreement to hold private personal information in confidence. On July 6th, I stated that if no such agreement is filed before 4:30 p.m. on July 9th, I would issue further orders I deem appropriate. Prior to issuing any such order, I invite the parties to provide comments on the following draft language. So you filed an order telling Karen Reed's attorneys that you didn't want any conversation regarding their conversations about trying to come to an agreement about this language. And then you file an order saying, I invite all the attorneys to comment on the language that I propose. Deposition testimony taken in this matter in the form of video or audio recordings or written transcripts, including private personal medical information learned at any such deposition or through discovery, shall not be disseminated and shall only be used for the purposes of this case or McCabe versus Reed. That's the defamation case. Each party is requested to provide written comments, 1 page and no more, to the above on or before 3 p.m. on Monday, July 13th, 2026. As to other pending actions, although the parties to any related matter are free to agree to such limitations, I will not enter an order in a matter not assigned to me. Well, you don't have the authority to. It's so frustrating to watch all of this unfold. What are we doing? I just want consistency of the court. It is the court's job to bring things to order. And it is not lost on me that the court wanted to talk about everything being made a spectacle while the court continues to fan the flames of a spectacle. Thanks for joining me. If you enjoyed this episode and don't want to miss updates on your favorite cases, you're going to need the Law Nerd app at lawnerd.app.com. That way you can stay in the loop on the cases that matter most to you, and you never know when you're going to catch feelings for a new case. So make sure you get it for free on iOS and Android. Thank you for being here, and thank you for being a Law Nerd.